name is Mike Douglas, and I'm the chair of the BHBA's Ethics and Legal Malpractice Law section. Thank you for joining us in what I am sure will be a really, really enlightening CLE session on an emerging area of the law right now. I'm delighted to introduce our speakers, Yosi Yahoudai, Monica Washington Rothbaum, and Jonathan Sanchez. Yosi is the co-founder and managing partner of J&Y Law Firm, a personal injury firm with 21 offices throughout California. His practice focuses primarily on automobile and motorcycle accident cases involving catastrophic and life-altering injuries, as well as premises liability, product defect, elder abuse, and wrongful death cases. Yosi has received numerous awards and recognitions, including Rising Stars by Super Lawyers Magazine, the National Trial Lawyers Top 100 and Top 40 Under 40, a Martindale-Hubbell AV Preeminent Rating, and lifetime membership in the $1 Million and Multi-Million Dollar Advocates Forums. During law school, Yosi served as a judicial extern to the Honorable Alexander Williams III and as a certified law clerk for the Civil Liability Division of the City Attorney's Office. Monica Washington Rothbaum is the COO and a senior attorney at J&Y Law Firm, an attorney with over 2 decades of experience in corporate governance, legal operations, and strategic business planning. Monica is licensed to practice in Maryland, Florida, Washington, D.C., and New York. Before she joined J&Y Law, she served as the Chief Operating Officer at Bogan, Munns & Munns, a full-service law firm with a significant personal injury practice, and as a Managing Director and Deputy General Counsel at the American Automobile Association. Monica also clerked for Justice David Souter at the U.S. Supreme Court and for Chief Judge Harry Edwards at the U.S. Court of Appeals for the D.C. Circuit. Jonathan Sanchez is the marketing director at J&Y Law Firm, where he leads brand strategy and growth initiatives with over 17 years of experience in marketing across the legal, technology, manufacturing, e-commerce, and advertising sectors. Jonathan brings a combination of creative strategy and analytical expertise in the firm's marketing efforts. His experience spans both business to business and business to consumer campaigns with a focus on digital and traditional marketing, creative direction, and strategic partnerships. So with that having been said, please join me in welcoming our really experienced panel. And I will now turn it over to you, Monica, to get us started.
Great. Thank you, Michael, for the introduction. Good morning, everyone, and thank you to the Beverly Hills Bar Association for hosting this program. As Michael said, my name is Monica. I'm the COO, and I'm really pleased to be joined here today by Yosi and Jonathan. So we're J&Y Law. One of the great things about our law firm, particularly in the past couple of years, is the tremendous growth we've experienced. And I could define growth in a lot of different ways, but for purposes of this presentation, I want to talk about signups. So we have a strong in-house marketing lead generation department that's led by Jonathan Sanchez, our marketing director. And then Yosi is really responsible for our external lead gen. And the two of them are this powerhouse of lead generation. And month over month, we're increasing signups. So, of course, when SB 37 came down the track, we were concerned. And we took our time and we dug into the law, and then we also built a compliance framework. So what we're doing today is sharing some of that with you so that you don't feel as overwhelmed by all the intricacies of the legislation. So Jonathan, can you start the PowerPoint for us, please?
Absolutely. 1 second here.
And while he's doing that, I can get into sort of our learning objectives, right? So we've got 3 objectives. We want to understand what SB 37 changed in California legal advertising. We want to identify the risk areas in AI, lead generation, and intake systems. We want to apply a practical supervision framework for compliance, and then build the defensible review and monitoring workflow. So you can skip ahead, Jonathan, and then one more, and then one more. Great. Okay, good stuff. All right, so you know that I clerked, and whenever you are trying to understand a law or regulation, you really want to go back to the history. So let me take a step back, and then we'll take a step forward. So SB 37 isn't just a statutory amendment. It's a structural shift in how California regulates the legal marketplace. Yes, it's about advertising, but more fundamentally, it's about authenticity, attribution, accountability, and public trust. Okay, so let's talk about the legislative timeline and some of the legislative history. It was introduced in December 3rd, 2024 by Senator Thomas Umberg. It passed the legislature, both houses in 2025, and it was signed by Governor Newsom on October 11th, 2025, and it went into effect on January 1st, 2026. So it amended and expanded several sections of the Business and Professions Code. I'm not going to give you those, you'll just forget them. But know that the vote margins were overwhelming, and this was really, didn't appear to be controversial in Sacramento, right? Why is that? Because it was framed as consumer protection. So to understand SB 37, you have to understand what was happening in the marketplace. So over the last decade, legal advertising has changed dramatically, right? Algorithmic targeting has replaced billboards. Yeah, we see a lot of billboards, but there's a lot more digital advertising. Lead aggregators replace direct intake. Call centers are replacing an office consultation. Influencers are replacing testimonials, and AI is generating ads, avatars, scripted intake. The legislature recognized this widening gap between who appears to be communicating with the consumers and who is actually responsible for the communication. So some purposes of, that come out when you look at the legislative history, it's an attempt to modernize attorney advertising law. So because existing statutory laws are written long before the digital marketing area, it expands this definition of advertisement to cover all written, recorded, electronic, or online communications intended to promote legal services. So you're including websites, paid digital ads, landing pages, and also lead generation content. It's intended to protect consumers from misleading practices, because the legislators concluded that many legal advertisements were creating unrealistic expectations about outcomes, lawyer identity, or experience. And so it tightens prohibitions on false or misleading advertising claims. Third, it addresses unlawful solicitation and referrals. So the bill strengthens California's longstanding outlaws of runners or cappers, right? People paid to solicit clients, and ambiguous third-party referral services by extending these enforcement tools, including a private right of action that allows individuals to sue over unlawful or misleading advertisements. And then fourth, as I just already alluded, it authorizes civil actions with statutory damages, injunctive relief, attorney's fees, and other remedies. And it's explicitly designed to empower consumers and other affected parties. All right, so to dig into the details of SB 37, I'm going to pass it now on to Yosi Yahoudai.
Thanks, Monica, and thank
Sure.
you everyone for having me. It's a pleasure to be here. So let's look at what SB 37 actually does. It expands the scope of advertisement. In terms of how it's defined, SB 37 defines advertisement broadly as any written, recorded, or electronic communication, public or limited audience that encourages someone to hire a lawyer or a law firm. So practically, it's not just TV and radio. We're talking everything here. Websites, landing pages, paid search, social, drip campaigns, and co-branded microsites. So it's everything that we do. So let's go into the content prohibition. I want to walk through like a red zone list of things we can't do anymore. We can't make any guarantees or warranties of success. So, we used to see ads saying like, oh, 98% success rate, 99% success rate. It's not allowed anymore. We used to see a lot of quick cash or immediate settlement type claims on ads. Those are no longer allowed. So be careful with those types of claims. There's no more impersonations or deep fake style use of name or voice, photo image implying a lawyer or a client or a dramatization without any disclosure. Um, any ads with spokespersons, they're not allowed unless there's a disclosure of title. So, things can be done in terms of, impersonations, deepfake style methods, but there needs to be specific disclosures. Without those, you'll be in violation. Again, if you're going to be talking about your skills, your experience, your record, nothing can be misleading, deceptive, or false. So if you're going to make a claim about those things, you have to make sure that if it comes up, you'll be able to objectively prove it, and actually have, evidence that shows, yeah, this is our experience, this is our record, so that there's no gray area. And then a big one are the awards. A lot of people have these, what they're called pay to play awards, where as long as you pay a membership fee, they give you an award. So those are no longer allowed. Awards are still allowed to be displayed, but they must be from organizations that are bona fide organizations where you're genuinely voted in. There is an objective voting process, and it's not just purely pay for play. So be careful with those. There's also mandatory disclosures for all our ads. Every ad needs to name at least one California licensed lawyer or law firm or certified referral service. Um, you must disclose your city, town, and county of a bona fide office location, or you can use the state bar address of record, but I don't recommend that. Of course, much better to use your own address. And then for any character limited platforms where there's not going to be enough space to have a full disclosure, like a Google PPC ad, you have to have a compliant link to a landing page with a full disclosure that satisfies all the requirements. Now, on to enforcement. This is the scary part, I guess. If one was to make a complaint, they would file a complaint with the state bar. Personal service is required on the attorney, and the advertiser must provide a copy to the state bar. The nice thing is that there is a cure period with all these complaints, meaning if a complaint's made against you and it deals with a digital ad, you have 72 hours to take it down. And if it's a non-digital ad, you must take it down as soon as possible, but no later than 30 days from notice. So that is a huge plus for us attorneys advertising. And now for practical risks and lead gen and intake, I'm going to pass it on to back to Monica.
Monica, it looks like you're muted.
Thanks, sorry about that. So yeah, we many of us use lead generators. They help augment some of our in-house marketing efforts. And so, we wanted to highlight some of the risks of using these lead generation sources. Be careful of these co-branded landing pages with aggressive claims about what you're going to win, or millions and millions won and things like that. Be careful of SEO vendors that are drafting unreviewed content. Now that AI is available to pretty much everyone, they can just generate these AI blogs and things like that that can have content that is simply not true. Be careful of AI chatbots answering legal questions, and then also shared referral funnels that obscure responsibility or even impersonate different types of helpful resources, sort of coalitions that they're lead generation companies, but they're fronting themselves as coalitions or helpful resources. So be careful of all that. And know that when you use these lead generation companies, it's your state bar number that's going to go on the complaint, right? And that's because this is all tied to your ethical responsibilities. It's Rule 7.1, which is against false and misleading communications. 5.3, which is your responsibility for non-lawyer assistance, and even Rule 1.1 regarding your competence. So let's go to the next slide. We put together just a quick heat map so you can know where to focus your attention. With respect to landing pages, chatbots, and intake scripts, those are high risk. They're high volume, but also a lot of high risk. Awards and specialization claims are also high risk, but lower volume. And that would be, specialist or expert, or even using influencers or celebrity spokesperson that are making exaggerated claims. Lower risk, but also high volume is educational content if you review it, right? If it's a blog and it's reviewed, it's a little lower risk. Community announcements still need disclosures if they're an ad. And even lower risk, didn't make it on this heat map, would be the brand level PR that doesn't have the direct call to action. All right, Jonathan, you're up.
All right, thank you very much. So we're very happy to share with you all this information because we've been developing this in-house here at J&Y Law as part of our marketing efforts. What we've put together is actually what we call the 5-step compliance loop. So thinking in terms of the good, the bad, and the ugly of SB 37, right? We've covered the bad and the ugly. Now let's talk about the good and how we can implement this into your workflow. So the first thing we do is we want to make sure that we inventory all of our advertising channels. As both of my colleagues were mentioning, this could include websites, landing pages, any ad copy that is out there, either published by your team or vendors that you're working with, or even third parties that are doing it on your behalf. So making sure that you have inventory of all of that. What we do here at J&Y Law is that we actually go through every single ad that is published. We inventory that. We create an archive of screenshots. We have Excel sheets. So we just make sure that we're keeping a log of everything that is being published so that in the event that, obviously we're preventing it, but if it were to happen that somebody were to file a claim, we have a log of everything that was published, timestamped, and also with the URL so that we can prove that we have been complying. We're wondering also if there may be some bad players or bad actors out there that may create fraudulent claims. And so in that case, you can also safeguard yourself by having this archive of all of your advertising as part of your protocol. The second step is to assign an attorney to oversee the approval process. So we've heard oftentimes lead gen companies will focus on results. They will connect with attorneys to discuss overall, how many cases are you interested in acquiring? What does your budget look like? What is it that you're trying to achieve? You could take a certain number of cases out of the market share. So they're very pushy when it comes to their sales pitch. However, they don't necessarily share the framework with you. So they don't offer you insights into how they're putting together the ad copy. They don't share the images that they're either creating via AI or that they're getting from different stock publishers and so on. So now we encourage everyone to actually have an attorney overseeing that. As much as you may have a marketing department or a trusted resource, it is important that you have an attorney involved because it is your license that is on the line. So that is obviously step 2. Step 3 is to, again, go over that approval process. So we encourage you to create some sort of internal system where you can say, for example, we are interested in running a new campaign. At that point, you work with your marketing team. You put together the ad copy, all of the different assets that are involved. And then at that point, you go through an approval process. And obviously, this is something that a lot of people are accustomed to doing, especially when it comes to presenting information or even sharing documentation, and obviously in your legal expertise as well. And so we think that it's very good to have an approval process so that you can approve everything before it goes live. The fourth thing also ties into the first point, which is to archive everything that you have. So if at one point you were running ads, make sure that you archive those and you have a timestamp for them. And then maintain records of any edits or anything that was being done to that ad so that again you have a history of how you're running your marketing. And then the last thing is to make sure that you're constantly monitoring this activity. Oftentimes we know that agencies will launch pilot campaigns that are typically around a 90-day campaign, if not longer. So we would encourage you to do it quarterly, but obviously if you have the bandwidth and the resources to do it as often as you can, because this will allow you to remedy any situation quickly and avoid obviously any sort of pitfall from that. Now, when it comes to an actual checklist, so something that we're using here at J&Y Law is that we're checking through all of our ad copy and all of our marketing and making sure that it complies with these 4 questions. So number one, are the required disclosures included in the ad? As Yosi had mentioned earlier, there are often times where we have character limits. So for example, on Google Ads, a headline can only have 30 characters. Unfortunately, you can't fit a disclaimer within 30 characters. So you do have to include that disclaimer on the landing page. And some get away with just linking to it. Others include it in small font toward the bottom. But it is important that you include that or at least have an option where somebody can access that. Number two is, are the claims that are being mentioned, are they substantiated and are they non-misleading? So again, kind of what Monica and Yossi had been mentioning earlier. There are a lot of organizations out there that are pay for play. They will give you an award or they'll name you as number one in a certain area or in a certain region. But is that a neutral party? Is that an organization that is reputable, that is not just for lead gen purposes? The reason being, if it's mentioned as an advertisement, then that does implicate you. And so it's important to make sure that these are substantiated and that they're non-misleading because we can't mislead the public. That's really the heart of SB 37 is offering that type of transparency. Number three is, are dramatizations properly disclosed? Everyone is using AI, and I think I can speak for most companies. A lot of us are taking advantage of that. Unfortunately, it's still not a highly regulated industry. And so oftentimes images will be created that look very real or can portray a situation that obviously through prompt engineering, you can make it look almost identical to a situation. However, if somebody were to run across that, or let's say, for example, you're creating a situation that was a client's story and it's not the actual client, it's a dramatization or it's AI, we have to make sure that we include that in there. Otherwise, it could implicate some consequences here. So you want to make sure that you incorporate that. We sometimes include it as a little funny byline saying, just so you know, this is AI, and we'll try to make it humorous. But in terms of including that, it is important. And then the last thing is, are the vendor scripts and chatbot responses reviewed? I'm sure many of you here have received cold calls or emails where a vendor will pitch their AI chatbot or their services to you. And so you just got to make sure that you have oversight over that script. As my colleagues had mentioned earlier, we can't allow for these chatbots to offer any legal advice or to even portray themselves as the actual law firm without a disclosure, and making sure that you imply that this is an AI chatbot or that this is an AI response. Anything that has to do with get a quick evaluation on your case, or do I have a case? Yes or no. Those are the types of things that you want to make sure that you're reviewing with your vendors, because unfortunately, those are now being highly scrutinized. And with that, I will actually, oh, I'm sorry, actually, before I step into that. So as far as vendor contract safeguards, so this is now, again, obviously a lot of you that are perhaps maybe a sole practitioner or don't have a marketing team on hand and work with vendors. this is something that you want to make sure that you spend a little more time on, especially as you're vetting them. So some of the vendor contract safeguards that you can incorporate into your vetting process is compliance warranties. So make sure that you have approval rights, like we mentioned before publication. So you want to make sure that you incorporate that into your contract, that you have the final say in every single piece of content that is published on your behalf. Indemnification provisions, so making sure that that is included in your contract as well. Rapid takedown obligations. So as we've described here, there is a timeline that is assigned as soon as a claim is processed. So you want to make sure that you have some sort of procedure for if an ad, is flagged, how quickly can you take it down? How quickly can you identify where it's been dispersed? Because it's likely that the ad is probably not just running on Google, especially if you're using a vendor. It's likely running on social media or on an email campaign and so on. So how quickly can all of that come down? And then last thing is the audit rights for scripts and recordings. So again, making sure that you have that authority over what it is that these tools are saying on your behalf. And with that, I will hand it over to Monica. Or I'm sorry, Yosi.
Yeah, thanks, Jonathan. So SB 37 also affects referrals, joint advertising. So a lot of attorneys, use lead gen companies to generate cases, and we're still allowed to, but SB 37 has definitely tightened the expectations around joint advertising. So if you're going to be in a joint advertising relationship with another company, it requires the law firm and the company to enter into a joint advertising agreement where each law firm attorney takes liability for the ad content. So what that means is if they violate SB 37, you're on the hook. So it wasn't like that before. Before, if they generated cases and they got you cases, that was great, but not anymore. It's got to be in compliance with SB 37. So what that means is you really have to review all ads before they go live. You have to have final say. You have to have veto power. If something violates part of this provision, you need to prevent that from going live, because if it does, you will be held liable. So make sure you do that. If you work with a company that refuses to share their ads with you, that's a huge red flag. I would definitely not work with them. There's something there. So as long as they share with you, you approve everything ahead, and everything's compliant, and you have this agreement with them, you should be okay. And then with referrals, if you are getting referrals from a law firm that enters into joint advertising agreement, you want to make sure that that law firm also is in compliance with SB 37. You don't want any issues with that. And this is a particular area of importance to us because we're a heavy referral type law firm, both in referring out cases and accepting referrals. And for referral relationships, you want to remember you're not just evaluating the legal skill of the firm, you're evaluating their infrastructure, their intake, their advertising, their disclosures, and their scripts. And with that, I'm going to send it back to Monica.
Okay, so I'll just wrap it up. Look, we for those of us who are have more volume practice, we're always looking for ways to innovate. We're always looking for ways to differentiate. We're always looking for new tools and avenues for attracting business. This isn't to limit innovation, but it does mean that we have to be more deliberate in creating supervisory systems that protect our innovation.
Alrighty, so it does look like we have a question from Megan Pollia regarding some clarification for let's see, the bill language requires disclosure of the city, town, or country.
Yeah, I can take that one.
Okay.
Yeah, the bill does use the disjunctive, uses or. If you wanted to just put the city or town or county, it looks like you could do that. Again, I would go back to the purpose. Again, that you always start with the purpose of the bill. It's consumer protection, and you could put one if you wanted. You could put two if you wanted. Just remember, it's the intent of the bill that you want to go for.
Great, thank you. And it looks like we did receive another question online. How um, how does SB 37 define AI generated or synthetic content in practice, and where is the line between minor AI editing and full-on AI authorship?
It says electronic. So I don't know that it gets into the weeds there.
Okay,
So it's
perfect.
defined more broadly than that.
Hey, I had a quick question for the panel. This is Mike Douglas here. Have you guys had any conversations with the lead generators at this point to sort of prime the pump on these discussions? Seems like you guys are pretty heavily involved in marketing efforts, so this would be a pretty big ship to turn. Have you had those conversations with your partners in the advertising space?
Yes, of course.
How's
Had
how's
to.
how's that been going?
Overall, well, they understand. It's very stressful for them. It adds a lot of work to them. It really changes everything. But if they want to continue being in the legal space, they have no choice. But it has made it a lot more difficult on them for sure.
I think we've had, we've gone a couple of rounds on the contracts. Sometimes with the lead generation companies, they want to present something that's almost like a shrink wrap contract, right? You can sign this or not work with us,
Yeah.
but we are lawyers, right? We know that we can always change contract language, and we dig in our heels on what we consider to be non-negotiable, and we have walked away from lead generation companies that will not protect our non-negotiables.
We have. We did walk away from one.
Mm-hmm. Jonathan, here's a question for you. What's your recommendation for reviewing past content that was posted in a large volume? We've got two different people asked that same question.
Yeah, as far
I
as
think
our team here at J&Y Law, what we've told ourselves is when in doubt, throw it out. Just archive it. If you feel like it didn't fully comply at any point in time, you want to make sure that you just take it down if you can. So like, for example, on our social media channels, we went through and scrubbed all of the content. It was a major project for us. Thankfully, we had the resources, thanks to our leaders as well for giving us the time to do that. But it was a matter of just going through and scrubbing everything that was done prior to implementing this new process that we've developed, and then looking ahead. So how do we prevent this from happening again, if it were to happen? And that's where we came up with that compliance plan, as well as creating really just a log of all the assets that we have out there so that we know exactly what it is that is being portrayed on our behalf. So going through, unfortunately, it will be time consuming. I won't shy around that, but it is worth it, especially considering the fact that anyone can file a suit at this point. It's really just open to anyone. So it could be a competitor, it could be a client that possibly you turned their case away and they got riled up and decided to go through your Instagram. And maybe this is somebody that spends a lot of time reading about the law or understanding compliance regulations. And so they may go and flag your ad. And so it's really important that you invest the time and the energy in scrubbing all of your content. When it comes to your website, it may be a little easier depending on what you're using. So if you're on, for example, on WordPress or some of these other tools, they sometimes have some sort of like search and replace. And I know I'm diminishing the actual process for it, but it's a matter of using these tools and taking advantage of some of the plugins that they incorporate. So like, for example, you can have a website publisher go through and find things that are probably against compliance. So for example, as my colleagues had mentioned, things that talk about any guarantees, any amounts, any quick cash, anything that has to do with some sort of hook that a lot of agencies or writers have incorporated in the past. So you can quickly just use these tools to search. You could also even export a lot of these files from, for example, Google Ads allows you to export everything onto Excel. So you can do a quick search and figure out which ad and which ad ID incorporates this so you can go back into Google or use a mass upload tool and re-upload all of your ad copy. So it is a matter of just going through using the tools to the best of your ability, and then possibly even counting on outside resources to help you do that.
There's a question about whether hashtags count for naming the city. I wouldn't, I'm not going to opine on that, but if you go back to the statute, it's, would that be false, deceptive, or misleading? Right? If you had you had a hashtag a city, but then you also had hashtag other cities. So I think you really, you want to, again, keep going back to the purpose of the statute, keep going back to the language, and then, ask yourself, could a consumer or would the state bar consider that particular practice to be false, deceptive, or misleading?
Mm. Yeah, as far as hashtags go, I don't know that that would
Yeah,
cover you. You'd have to be explicitly mentioning the city.
that's that's
Yeah.
a good one.
I do see here a question regarding best of competitions. I'm familiar with these. I've seen some, especially like magazines and even some directories. They almost treat them as business directories to highlight businesses in the city. That is a voting process. So if you're not paying to be included or named, I believe, and this is just my personal opinion, that it is safe to use that. I have seen some cities, for example, like in Playa Vista or in Southern California, there are a lot of them where they'll mention like best of Torrance or best of Manhattan Beach and so on. So my assumption is that those are safe, but if it's an organization that will send you an email and say, we will be recognizing you as a lawyer of X, Y, and Z, here's the fee to be included, then that is a pay for play situation.
Alrighty, so it looks like we received another email. For small firms without in-house counsel, what's a realistic supervision structure like?
Yeah, it really depends on your volume, right? And how conservative you are in your calls to action and what you're saying about your firm. But if I were a solo or 2 or 3 person firm, I'd definitely make sure that we have attorney oversight and that you're cataloging everything that you're putting out there. Jonathan, what would you add? If we didn't have you, what would we do?
Yeah. Yeah, well, that compliance checklist that we had shared with you all today, I feel would be effective because it at least it organizes your thoughts on this. So it'll help you design a framework for yourself, and perhaps maybe you don't have the bandwidth to fully do this in-house and you'll have to outsource it. But it'll at least create a checklist. So like Monica was mentioning, create an inventory of all of your ads, or at least those that you have access to. Ask your vendors to do the same. They should be able to share that with you. If they're not, obviously, like Yosi had mentioned earlier, that's a big red flag if they're not willing to share that with you. And then a lot of the tools themselves, if you have access to Meta, if you have access to Google, if you have access to some of these other media companies, you should be able to access your content on the back end if you are truly the owner of that advertising account. Some of these lead gen companies or marketing agencies will oftentimes create profiles for you, and you are not the owner. In that case, you should actually reach out to them and say, may I have access to this profile so that you can do your auditing in the event that they're not doing that for you. So hopefully that framework does help. I know that you all received it, but in any event, it's something that we recommend, but obviously you can get really granular with it or just use it more high level when you're connecting with your vendors or any other resources that you don't have in-house.
Another question within the Q&A, Agatha Riley is asking, if we use stock footage in our creatives, what disclosure language is required? Where must it appear?
That is a good question. On some of the research that I did regarding stock footage, I believe if you're paying a license, and it's not depicting an accident. So if it's more of just like somebody sitting at a desk, that should be fine. But if it's depicting a scenario or a situation that you're using for advertising purposes, like for example, a car accident scene, if you're replicating a scene that one of your clients endured during their accident, we know that there's television commercials that use a lot of dramatizations. You need to include that in the disclaimer. So making sure that it's a dramatization or that it's not the actual scene, but it's either actors portraying, sorry, the client or something to that effect. We don't have the exact terminology that must be included, but I'm sure all of your attorneys, so you can come up with some sort of legal jargon for it, but it should be implied that it is either not your actual content, but in fact something that you are purchasing or using for dramatic effect.
Yeah, so the bill, SB 37, prohibits impersonations that would be false, misleading, or deceptive. So if you are taking stock, as Jonathan said, if it's just stock footage of the city, LA, that's one thing. But if you're dramatizing certain events, then you need to disclose that this is an impersonation or a dramatization.
And it looks like Megan has another question. For
Sure.
videos that feature attorneys, does their role have to be featured on screen in the video or only in the caption?
I'm not quite sure what she means by that, what the question's getting at. Does the role of the attorney, you mean whether or not they're lead, or what do you mean?
Okay, I guess perhaps we can. All right. So it says the role. Okay, so for social media videos, the role of the person speaking, parentheses attorney. Um, okay.
There was a question about is the law retroactive? It is. So if you have anything on live on a website, either take it down or make it compliant.
Yeah.
I have another question here. As AI marketing tools accelerate content production, how can firms scale review without paralyzing growth?
Yeah, that's a great question. You have to have your review system in place, and with any AI tool that you're using, you have to you should combine it with human judgment. So you'll need to get good at scaling this review process. I think it's a good thing, right? I think it's a good thing that people can't just generate things, willy-nilly with AI, because you could generate hundreds of articles a day, and then just put them out there. I think it's a good thing that now we are required to review each and every article, and that we have to put our name on it.
Great, thank you. And do you anticipate foreseeability and reliance doctrines expanding firm liability for AI-generated misinformation?
Yeah, when you have these when it gets to the courts, yeah, I think courts are going to start looking at foreseeability, but that's with any, with any law, like any sort of uh civil, action, when that's approved, you're going to end up having to deal with foreseeability at some point in time.
All right, so I actually see a question here regarding risk and enforcement. It's kind of a twofer. Are we likely to see enforcement driven primarily by competitor complaints? And what level of statutory damages exposure should firms realistically be preparing for?
Yeah, do we think that they're going to be competitor firms posing themselves as consumers for purposes of the statute to bring action? That's possible. And SB 37 authorizes damages between $5,000 and $100,000. Yeah, I could see people asking for the max. Yeah.
Yeah, and I can add to that. I think even now our industry is already experiencing that with competitors that use unethical practices to be in position one or two, both on Google and on Meta and all these other companies. I do have a feeling that there will be bad players that come in and start just acting as the,
Yes,
they're going to start policing
for
each,
sure.
which honestly, I think maybe a good thing. It'll keep us all honest. It'll create a greater responsibility for both the publisher and the one that's writing the content. But I'm probably just using an assumption here, but based on my experience, I've seen competitors flag each other's Google business profiles as fake or post fake reviews just so that they can bring down their star ratings. Unfortunately, this industry is highly competitive. So the idea of that being true, I think, is likely rather than it not.
Thank you. And then it also looks like Agatha Riley is asking a question as well in our Q&A. When designing graphics that reference past case results, even if we include a disclaimer such as past results do not guarantee future outcomes, could that be considered misleading under SB 37? Is this considered a gray area?
I actually believe you'll be safe with that because that's something that I've seen more often, especially with those firms that have really advanced in their compliance. You're including a disclaimer as long as you have the case to back it up. Some of these cases I know follow non-disclosure agreements. So if you're not even able to share the amount, you likely probably shouldn't be using it in your marketing material. But if you have that case, if it's available to be found both in public record or private, whatever it is, you obviously you can display the amount, but you do have to make sure that that disclaimer is included so that it doesn't allude to that being what every single accident will generate for that client.
All right, I guess Agatha's also following up regarding is content featuring written client reviews, including reviews posted on third-party platforms such as Google, Yelp. Are they safe to share under SB 37?
My answer to that would be yes, and the reason is because it is publicly available. So if the client published a review on Google and you're screenshotting that and using that in your marketing, it is actually displayed on a public forum. It isn't misleading in the way that SB 37 is written. You're not making any claims or any guarantees. All you're doing is you're sharing content that somebody shared with you on a public forum, which could be considered neutral in my case. However, anything that we publish that has to do with results, we always make sure to include a disclaimer just to safeguard ourselves. Because if the review itself mentions the results that were obtained, or if it makes any sort of claim, for example, some reviews mention these are the best personal injury attorneys in California. That sounds great and looks great and is obviously a wonderful accolade to attain, but we like to include a disclaimer just to safeguard ourselves. And it's typically a short one, as we had mentioned earlier, past results do not guarantee future outcomes and things like that. So I just say err on the side of caution. If you're wondering if something doesn't follow the protocol, just include a disclaimer or even link to one at least, just so that you are completely confident that it's something that does comply with SB 37.
Great, thank you. And it looks like we have another question from Jack Russo. He's asking, how will BNP 17200 play into litigation?
I suppose you could bring a case under 17200, but then also 6158. 17200, as I understand it, is it prohibits unlawful, unfair, or fraudulent business acts. And then this one is obviously oriented towards misleading, false, deceptive, and misleading practices. So you could bring an action under both, I would imagine.
Right. And it looks like I have there are two questions now, mainly regarding vendor management. How should firms handle vendors who are resistant to pre-publication approval agreements?
Don't work with them. There's a reason. Why wouldn't they be transparent? If they're doing nothing wrong, they should understand the gravity of the situation. That's a huge red flag. You're walking into a danger zone. Just don't even think about it. Just walk away. It's not worth your license.
All right, thank you. And then the next one being, what documentation would you want in your file to demonstrate reasonable supervision during a state bar inquiry?
I would say document everything.
Yeah.
Screenshots, URLs, timestamps, email exchanges, anything that can be possibly used against you, make sure that you're on top of it.
And I put the framework, your review framework as well, to show that you have, in good faith, attempted to comply.
For sure.
All right. Let's see, one last one just came in. Let's see here. What common mistakes would you say that firms are making with required disclosures under SB 37?
A good one.
Maybe being more reactive than proactive, right? We've been talking about, how do you lean forward? How do you create a compliance framework? How do you instill discipline among the members of your team, whether you have a marketing team or whether they're just attorneys? I think that, maybe kind of thinking, there's so much, there's so many other people out there not complying with with SB 37 that I'm not, it doesn't really matter to me. I mean, we can drive down the road every day and there's still billboards saying, millions won and we're the best and things like that. We may not see the little small print down there. So we think that, look, those guys and gals are going to get it before I do. And I think that would be unwise.
Great, thank you, Monica. And in the Q&A, I guess we have a question from Aaron Steigerwald. Do you have to disclose the year of each award in non-pay-to-play awards?
I believe that actually is based on the compliance regulations for each of those awards. So I know, for example, you can't tout yourself as a super lawyer unless you include the year and also the trademark. The same goes with best lawyers, even like top verdicts and so on. Those are all assigned per year. So you're not allowed to use any of their trademarks unless you're complying with those policies. And so typically, if it is based on a year and it's not an evergreen award, you should incorporate the year. Otherwise, you may end up forfeiting that award if that publisher would have find you not following their guidelines.
Thank you, Jonathan. And it does look like Megan did reach out with some clarification regarding her question area about captioning. What she had meant originally was that when an ad features a video with an attorney speaking, does the attorney's title have to be featured on screen in the video portion, not only in the written caption?
SB 37 just says that the name has to be conspicuously displayed or intelligible if it's audible. So I would, I would use that as my guide.
And even just marketing best practices. I mean, understanding that a lot of people watch videos on social media with the audio off. So having your attorney's name on the video, I think is a good idea. And it's also because why not? I would hate to think that a video circulates and goes viral and doesn't include Yosi or Monica's name on it. I would much rather, as a marketing person, make sure that we're getting their name out there. So my recommendation would be to always include it if you can. But obviously, to Monica's point, as long as it's somewhere displayed, I think you should be fine.
Great, thank you both. So it looks like that's it for the questions that I have here. Do any of you have any, extra closing remarks or review you'd like to provide to our audience?
I just think do great marketing. Keep your clients in mind. Always consider yourself their advocate, both when it comes to filing claims on their behalf, but also keeping your audience safe.
And I'd just like to say thank you. Thank you for
Likewise.
joining us today, and thanks so much for your questions. Love questions.
And
And
please reach out in the future. You can
Yeah.
email us, Monica, Jonathan, myself, all three of us, with questions that come up. I'm sure they will, because we're all navigating this for the first time. Don't hesitate to reach out via email, call, and we'll be happy to try to help out.
Great, fantastic. Thank you. So this concludes today's presentation. Thank you so much for an excellent program, and thank you so much to our audience for joining us today. Have a great day, everybody.
Thanks for having us. Thanks. Goodbye.